Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, Justice A.M. Khanvilkar and Abhay S. Vokha and J.B. Pardiwala, 3 judges bench, while deciding the case of Ghulam Hassan Beigh versus MURTY Margarez 2022 in SLP criminal number 4599 by 2021 on 26th, that is yesterday, 26th July 2022, held that the PM certificate, the post-mortem certificate, is not substantive evidence. Please remember. No doubt, Section 45 says that it is expert evidence, but it is not substantive evidence. So, you can't discharge the accused solely basing on the PM certificate. You have to look into the other circumstances also. That's why, please remember, I have been always telling you, please remember, the judgment is decided basing on the facts and circumstances of each and every case. Please remember, the facts and circumstances are not similar from one case with the other case. Every case will have its own set of facts and circumstances. Of course, there may be some similarities, but 100% they are not similar. 100% in total they are not similar. Even though while discussing about the stare decisions or the president will be telling you about 307 other cases, yes, definitely similar circumstances will be there, but not at all 100% same circumstances. Now the important point here is regarding expert evidence, that is right from section 42 of the Indian Evidence Act will be telling you, but please remember, even though it is expert evidence, it is not substantive, it is a corroborative evidence. This much the judge should know, right? Supreme Court held that the PMC is not substantive evidence and the accused can't be discharged solely based on it. So if you know the facts of the case, it is better for you to appreciate the same. Friends, this relates to crime number 26 by 20 under sections first registered under 147 unlawful assembly, 147, 354, 323 and 451 IPC. Later converted into 302 IPC and the court changed it to 304 IPC. So many twists and turns have taken place, right? So this relates to FIR 26 by 20 registered on 22-3 March 22nd of 2020 of Dhariwacha PS in Jammu and Kashmir. Basically, this is a land dispute. The accused are having dispute with the appellant, and actually the matter was pending in the civil court also. Ultimately, on that fateful day, that is on 22-3-2020, all the accused in a gory mob came upon the premises or the land of the deceased, land of the appellant, and they started removing the fencing. Then appellant interfered, his wife, who will be the deceased in this case, she also interfered, but those people, during the altercation, they have hit her with this allegation, with a wooden log, and also they used fist cuffs on her. Fist cuffs, pidigudur there, directly to say. Right? So, this man, the appellant, actually was caught by his hands. When he tried to interfere, he was actually not allowed because they were damaging the fencing. వాళ్ళు fencing జరగొడుతున్న వస్తే అడ్డం పడతాడని వీళ్ళు చేతులు విసి పట్టుకున్నారు. And his wife interfered and she was given fist blows, due to which she was admitted in the hospital and later she died. Right? So since the death is, in the opinion of the police, death is due to the handcuffs or fist cuffs are used by these people, they filed the charge sheet. Now when they filed the charge sheet, the accused, that is this is MUQBUL. So both of them are Muslims. So the accused person, actually they filed a discharge petition because there is no material in the investigation of the police. How? They based only on the PM certificate. So the judge, while framing the charges under 228 of the CRPC, right from 214, we'll be discussing about the framing of charges. So he learned that death is due to, the PMC disclosed that death is due to cardiorespiratory failure. Finish. cardiorespiratory. What is cardiorespiratory? Sudden heart attack. Simply in our words, we say it is sudden cardiac arrest. So what is the result? It results with the heart's electric system from pumping. Actually, the pumping system will be disrupted, as a result of which the blood will not come to the heart and it will not go from the heart. So the blood will stay at it is actually stops blood flow, as a result of suddenly the person dies. This is cardiovascular, already I told, cardiorespiratory failure, right? So the trial court agreed with the PMC, and therefore instead of 302 they altered the section to 304. That is culpable homicide not amounting to murder. If the appellant could have kept silent, it would have been better. But anyway, he has brought the matter before the High Court by filing a revision. So the charge sheet is not filed correctly, the charges are not framed correctly, so therefore they have gone for revision. 384, 385, you know. Right, then the High Court dismissed the revision. They said yes, the trial court is 100% correct. Then the matter came to the Supreme Court. So please remember, High Court of Jammu Kashmir not allowed. Therefore, the matter was brought before the Honorable Supreme Court of India. Supreme Court looked into the evidence of the prosecution. Supreme Court looked into the statement of the PWs recorded by the police under 161 CRPC. And the most important point is the dying declaration under section 32 of the Indian Evidence Act, the dying declaration of the deceased, which revealed that the accused trespassed, the accused outraged her modesty, the accused used fisticuffs, as a result of which only she died. So that means cumulative effect of the injuries as well as mental trauma. Not only so, a person how does she get this sudden cardiac arrest? Because of the cumulative effect, all these things. So not only the PMC should be taken into consideration, but the other circumstances also have to be taken into consideration. Anyway, the matter is remanded back to the trial court to think over the matter or to revise the matter and see whether section 302 will be so clearly yes, 302. Supreme Court opined that yes, it is a case under 302 because intention, all these things are there. So the trial court has to conduct trial under 147, 354 and 302 IPC as suggested by the police, but not under 304 IPC as suggested by the judge while framing the charges. So please remember, the judges also should be careful at the time of framing charges, right? So normally it may be otherwise also. As a senior man, I can say that suppose if the court did not alter 300 into 304, Supreme Court might have stated also that why you have not altered into 302 when the PMC is very clearly saying that it is only cardiovascular failure, because case depends on other circumstances. So we should not come and discuss more on this. But anyway, Supreme Court opinion is the best opinion. Therefore, please remember, the judge is not correct in holding it as a case of 304, but it is a case of murder. Okay, if you know this much, this is sufficient. Thank you very much.